Well, good afternoon, everyone, and welcome all participants and guests to Gowling WLG's US Tech webinar series. Before we launch, just by way of some immediate housekeeping, we wanted to alert all registrants who are seeking California CLE credit to please visit the all hands link, which we're posting now in the comments section of this webinar. The link should be clicked on as soon as possible for those who are seeking credit so that you can time stamp your attendance here at the session today. Hope everybody is safe and doing well. If you're coming to us from the comforts of your home office or wherever you may be tuning in for today's webinar. We're coming to you live from snowy Toronto, Canada, home of the NHL Stanley Cup hockey champions, Toronto Maple Leafs, circa 1967, but that's another story. My name is Henry Harris. I'm a business law partner at Gowling WLG, and I serve as the Canadian leader of our California regional team. Our firm acts for a number of Silicon Valley tech companies, ranging from everywhere from household names to more emerging growth companies, and many of whom are joining us for this webinar. So welcome to them and everyone. And by way of welcome, I'll introduce my partner, Brent Arnold, in today's topic in just a moment. But first wanted to provide some context. Our webinar is being presented in conjunction with the SVAGC, Silicon Valley Association of General Counsel, and its annual all hands meeting. Gowlings has been a longtime sponsor of the SVAGC, and I and other partners of mine regularly attend the all hands meeting and in person in Silicon Valley. And of course, this year are pleased that the meeting was able to adapt and that we were able to adapt and present today virtually. So today we're presenting the second of a three series webinar session where we've been exploring emerging trends and issues relating to advising tech companies. And just to give you some of the landscape, our first session was held last week, Thursday, January 21st, on cybersecurity and protecting your internal client. The session was recorded and will be available to anyone who's interested to access it online. Our third webinar in this series is coming up this Thursday, so in 2 days. And it's on the topic of artificial intelligence, AI from a European perspective. It's being presented by our London, UK partners, and we would welcome you to attend. For those who are not familiar with Gowling WLG, we're a global law firm of 1,400 professionals. We're in 19 offices, 19 cities worldwide, regionally, Canada, the UK, Europe, Asia, and the Middle East. So we're across 9 different countries. And with that, that brings us to today's session, which I'm excited to hand over, is on the topic of cross-border and international data privacy issues. I think it's fitting that it's the second of 3 webinars because there really is a lot of meat or substance to this session, a lot of interesting information to cover. So I'd like to get right into it, and in doing so, I'm pleased to introduce my partner, Brent Arnold. Brent is also based in the Toronto office. He's a commercial litigator. He handles data breach coaching and response, as well as data breach class action defense work. Among other positions, Brent is the recently appointed Vice Chair of the Steering Committee of the Cybersecurity and Data Privacy section of the Defense Research Institute, DRI, which is a US-based organization. So without further ado, I am pleased to hand over the baton to you, Brent.
Thanks, Henry, and thanks everyone for joining us today. So, as Henry said, we're going to talk about cross-border and international data and privacy issues. I have to start off with, we've talked about getting your credits, and I have to start off with the usual disclaimer that this isn't legal advice, it's legal information, and if you've got privacy issues, you should consult your external counsel or I guess solve it yourself with your general counsel. So let's talk about where I was hoping to take us today. It's going to be a bit of a whirlwind tour. So we're going to review some of the recent developments in the last few months and projecting forward the next few months in some of the bigger centers in the world. We're going to talk about the US. We're going to talk about Europe and the GDPR, and in particular fallout from the Schrems II decision a few months back. We're going to talk about your largest trading partner. I think we're still the largest trading partner. And we're going to talk about China. And we'll briefly touch on some recommendations, and then we'd be happy to take any questions you might have. So I'm going to spend probably the least time on the US because I would expect this is the jurisdiction that you all know best and know quite well. But as you know, just to set the table, in late last year, we saw the introduction of the California Privacy Rights Act, which updated the CCPA, which of course was already causing general counsel and external counsel alike plenty of heartburn as it was. The CPRA adds, it increases the scope of the act, but also decreases the categories of organizations that fall under its purview. It adds a new sensitive data category, which includes a number of fairly traditional for privacy law categories that we're used to seeing. It also mentions religious beliefs, biometrics, sex life, sex orientation, and health data. It doesn't have a GDPR style consent obligation, but it does offer greater control over data for data subjects. It gave us a new definition of consent, which is set out there and is a very specific and more prescriptive definition than we've seen in some other acts. So that's helpful. It also expands the requirements for what provisions you need in contracts between controllers and service providers. Now these contracts have to prohibit sale and sharing of personal information expressly. They have to prohibit the retention or use or disclosure of data except for purposes specified in the contract. They forbid combining data with data received from others. So if you're planning on making data pools with it, this is an issue. It also requires those contracts specify that personal information sold or disclosed by the service provider is done so only for the limited and specific purposes. That service provider is subject to the CPRA and has to provide the protections that the Act requires. And we'll see shortly, that's not necessarily the case in all of the jurisdictions that we see, but the mechanism is often what you see here, which is those obligations are extended by way of contract. The transferor retains the right to take reasonable and appropriate steps to ensure compliance with the Act by the service provider. The service provider has to provide notice to the transferor in the event that it determines it can't meet its CPRA obligations, and that is very similar to the application at the one of the inclusions that we see in the GDPR standard contract clauses. So one of the things you may see as we go through this presentation is we're seeing a bit of a convergence and similar developments in a lot of these countries. And the Act now provides a private right of action. There's some momentum possibly for new privacy laws in the coming year. We'll see whether this is overly optimistic, but there's certainly a great deal of that optimism. The International Association of Privacy Professionals expects that the changes in the California law over the last 2 years and the coming in of the new Biden administration, along with what we've seen as a gradual process of convergence between the Republican-sponsored bills and Democrat-sponsored bills dealing with data privacy, means we may actually see a comprehensive federal law, perhaps even this year. Business Insider is predicting that industry group pressure for a rationalization and clarity of the U.S. federal law is going to be another driver in that process. And we're already seeing the introduction of, I wouldn't say copycat acts, but very similar ones in other states that track the advances made in California statute. Washington State is now attempting for the third time in 3 years to pass a CCPA, CPRA like statute, and we'll see how that goes. Crossing the pond, we saw some developments in the GDPR this year as well in Europe, and among them, the new European Data Protection Board GDPR strategy, which is a 3-year strategy, was published earlier this month. And it deals with, comes in the against the backdrop of gaps and differences in national enforcement, making it difficult to make cases move forward, particularly where there's cross-border data issues. So the strategy here is to sort of offer some guidance to help rationalize the process and streamline it. So what the EDPB plans to do is to strengthen cooperation between the national authorities by streamlining these processes, implementing a coordinated enforcement network to ensure cooperation. And they may also establish a support pool of experts to share expertise between the jurisdictions and to aid in investigation and enforcement. So hopefully that will make a difference. What's it mean for you if your company is doing business in Europe? You've got data controllers, process monitors. They should be monitoring these new guidelines as they come out, and any future statements or opinions that sort of lend color and help interpret them. National authorities within the EU are going to start acting together to issue joint actions and investigations and procedures to enhance competition and consumer protection. So some entities have perhaps benefited from the lack of organization in this field. There will hopefully be less of that in the near future. We're going to see more cross-border enforcement within Europe, and it should be faster. And we're going to see more guidance on international data transfers between EU and the rest of the world, likely quite soon. Many of you will have heard about the Schrems II case last year, midway through the year. There's a ruling by the European Union Court of Justice, and it came down in favor of a privacy activist, Maximilian Schrems, who's been advocating against some of the arrangements put in place to facilitate data transfer from Europe to other places, and in this case, the U.S. Was at the center of this case. Prior to the court challenge, data controllers and processors could rely on the Privacy Shield transatlantic treaty that covered those transfers, and it meant that companies could transfer data without having to independently verify the adequacy of the privacy regime of the recipient state. That is no more. Because as we'll see, the court, the decision invalidated the treaty, finding that the U.S. measures were insufficiently comparable to the GDPR. One of the issues here being that data subjects' rights weren't actionable against U.S. authorities in U.S. courts. So it'll be interesting to see if the new U.S. federal law will bring along a private right of action, which is something that we've seen as a feature in most of the new statutes that we're seeing around the globe. Companies will now independently have to ensure that the data of the recipient state, in this case, data going to the US, will still have protection at a level comparable to the EU and the EEA, notwithstanding that it's not up to that level statutorily in the view of the EU. Now, some of the measures you can do to achieve this are familiar, I'm sure, to this audience. Standard contract clauses, as we see in the GDPR, binding corporate rules, as we see in the GDPR, codes of conduct and certification measures, all things that can be built into your contractual arrangements to give the EU regulators the comfort that they need to allow for the transfers. The Protection Board also published guidance on Schrems II last year. They're recommending measures to supplement the transfer tools to ensure GDPR compliance. They addressed transfer compliance and suggested that the data exporter will now need to be able to confirm that the data complies with GDPR in the sense that it's as limited as possible in scope, that it's all relevant, that the records are adequate and complete. All familiar principles under most privacy law regimes. There's a requirement for transfer tool verification. So where there's no adequacy decision by the EU, you'll have to rely on the tools in GDPR Articles 46 and 49. And you should be assessing on a rolling basis the third party, that's the recipient country's country law's effects, because you can have a situation where the third country's laws will lessen the protective power that you built into those contracts, given that statutes trump any contractual arrangements. For instance, concerns over the third party country laws permitting greater access to state entities than would be allowed under the GDPR. So all this to say, it's a lot more administrivia for everyone in the interim. And they should also be identifying and adopting supplementary measures. Again, some of these are the ones that we've seen before. There's an annex to the guidelines that also suggest things like hashing and encryption, more encryption than you would ordinarily have. So they do offer some very specific nuts and bolts means to ensure compliance. So what about Brexit? Now that we're in a new world order in Europe and the UK is pulled out, happily there's been chaos on the roads, but less so in the privacy space. There's a trade and cooperation agreement that came into effect this month. It's going to be formally adopted in February. And it allows the EU and the UK to develop and adopt data protection measures, including around data transfers. Unfortunately, they're going to be proceeding on parallel tracks, which means you could end up with incompatible laws, or at least very different ones when it comes to transfers. We'll have to see whether or not the sort of global convergence and thinking on how these things ought to work is going to help keep those consonant, or whether there's going to be perhaps a show of defiance by the UK as we saw around currency, and perhaps they'll take a different path. We'll see. For now, transfers of personal data from the EEA to the UK will be deemed to be transfers to a third country, requiring GDPR Article 46 standards, again, standard contractual clauses, binding corporate rules, and the like. The UK becomes considered a third country as of the earlier of two developments. One is the arrival of April 30th of this year, or the adoption by the ECC of an adequacy decision with respect to the UK privacy regime. Obviously, it's to be hoped that happens, because it'll mean that there's a smooth and simple mechanism in place and we don't just drop off a cliff, but we'll see. The UK has deemed the EU EEA states to be adequate on a transitional basis in the meantime, pending review. For alternative transfer mechanisms such as standard contract clauses won't be required for now. The UK has managed to sort out and arrange agreements for uninterrupted transfers with Argentina, Canada, Japan, New Zealand, and a few other countries. Those that don't enjoy that are going to require binding corporate rules. And of course, the UK is now no longer part of the GDPR's one-stop shop mechanism. So if you've been getting approval through Britain to get approval through Europe, you're now going to have to find another country to initiate that process. Coming over across the actual physical border to Canada, by way of background, privacy law in Canada is an area of split jurisdiction, and the provinces are either all under the federal law, which obviously also applies federally to federal matters, or they, unless they have enacted laws that are substantially similar to the federal law, which we call PIPEDA, in which case it comes within their own jurisdiction. About three provinces have done that so far, and their laws are at least as stringent as PIPEDA, and in some cases, arguably slightly more. Statutes and regulations in Canada don't expressly require additional consent to share or transfer data across organizations. So a transfer for processing, let's say, to a processor, and they don't deal separately with transfers across borders or internationally. Now, since 2009, the Federal Office of the Privacy Commissioner's stance on such transfers was that transfers of personal information to another organization in another jurisdiction are perfectly acceptable. It establishes some rules governing the process, governing the transfers, but it's deemed that transfer for processing, and that can include storage, is a use of the information rather than a disclosure. And that means that it doesn't trigger consent obligations under the Act. Assuming the information is being used for the purpose it was originally collected for, additional consent isn't required for the transfer. So we were all quite comfortable with that until 2019, when all heck broke loose. And I'm happy to, I recall that I was actually speaking at a conference on cross-border data transfers when the following happened, the day before I was to speak. The Federal Office of the Privacy Commissioner released its decision in Equifax, and it also released a document to the effect that they were starting a public consultation process to reverse the stance that they'd had before, i.e. the stance that transfer to a company to process outside of Canada was a use and not a transfer and didn't require consent. This tipped off a public consultation. It got the privacy community in Canada very nervous. I can tell you that the audience of general counsel I was speaking to in the States were also quite nervous about it. And because it was going to expressly contemplate an obligation to obtain prior consent or additional consent as data was crossing the border. And you can imagine how disruptive that would be to business if you've already collected this data and now to transfer it to, let's say, a parent company for further processing, just to simplify your business processes and not require you to duplicate everything in Canada. That would be enormously cumbersome for a lot of companies, and for some it would make their business models just impossible. All this came to a screeching halt when the federal government announced that it was implementing a digital charter for Canadians, and that was going to be followed by a revamp of the federal privacy laws. And that's where we are today, actually. The government's moved relatively quickly and is now considering Bill C-11, and under which cross-border transfers are still permitted on that basis. It doesn't distinguish between domestic and international transfers of information to a processor, and there are no more restrictions on processors outside of Canada than inside Canada. Organizations can still transfer that data without the data subject's knowledge or consent. So as I was saying, it allows transfer to a service provider as it's described in the Act. And then there's your definition there. And requires that it's, for the purpose of providing a service on behalf of the transferor to assist it in fulfilling whatever its purpose is with respect to the data. Here again, we see the introduction of a new private right of action, and we'll see whether or not that ends up being class action fuel. Organizations can transfer data, as I said, without the subject's knowledge, but the bill clarifies a few of these responsibility liability issues. Personal info gathered by the provider on behalf of the transferor is deemed to be under the control of the transferor, not the service provider, as long as the transferor is responsible for determining the purpose of the collection or the use or disclosure by the service provider. So even if it's not just a transfer of data to the service provider and the service provider is the one collecting the data, ultimate responsibility still lies with the transferor, as long as the service provider isn't stepping outside the bounds of what it's supposed to be doing under the contract. The transferor is still ultimately responsible to ensure the CPPA compliant protection. And that's the Canadian statute, not the California one with the same acronym, with respect to the transferred data. The obligations of the statute don't apply to that service provider unless it's collecting or using or disclosing the data for a purpose beyond, as I said, what's set out in the contract, the purpose for which it was to be collecting it or receiving it in the first place. So let's talk about China. A lot of interesting developments in China, and it's interesting to me that a lot of the developments I'm talking about today happened when the world and we were distracted with what was going on in Washington. It was a very busy end of the year for the privacy community. We saw the introduction of the Personal Information Protection Law. That's China's first omnibus privacy legislation that actually carves out specific individuals' data rights. It's remarkably similar to a lot of the previous it's remarkably similar to acts that we see around the world, but it's also quite similar to regulations that were passed in China. But this law grants enforcement rights to individuals for the first time. It's substantially similar to the GDPR. So you see access, rights of access, rights of rectification, and rights of erasure, the right to be forgotten, as it's sometimes called, which has been late coming to a few jurisdictions, including Canada. But we're now, with the new bill, the C-11, we may get it as well. Possible, well, it looks like China got there first. It's going to apply to all data processing in China. It's going to has extraterritorial application for products and services sold to persons in China, or for companies that are analyzing the behavior of persons in China. Now, here's where we see a bit of a divergence. You need specific consent to transfer the data to third parties, have to identify the recipient, the purpose of the transfer, the type of the data transferred, and the method of processing. Now, this doesn't replace the cybersecurity law that was already on the books, sort of an umbrella law, and most of the laws that this is designed to sort of replace or supplement were just regulations under the old law. There was a requirement under the CSL for regulatory approval for data transfer overseas, but they never did rough in any sort of process for getting that permission. PIPL implements GDPR-like structures with measures for network operators transferring data above a certain threshold level of volume of data. Now, if you're below that threshold, the organization can transfer data out of China if they do any of the following. One, get a data protection certificate. Two, enter into a contract with the recipient guaranteeing PIPPL compliance, like we see with the standard contract clauses under the GDPR, or pass a government security assessment. Now, if you're over the threshold, you have to pass the government security assessment, and there's no way of doing that yet. They're going to have to still put the requirements and the process in place to bring that to life. Regardless of the threshold, however, and here's where we see the difference with some of the other statutes we talked about, the transfer still has to obtain the data subject's consent to transfer. So in some ways, this is perhaps a surprise to those who follow China's politics. This is a very consumer-friendly and very citizen-friendly policy statute with respect to privacy. It's aggressive, and indeed, fines for an organization that breaches the act can start at a minimum of, they can go up to as high as 50 million. And I'm going to say this wrong. Let's go with RMB. So it can be a minimum. It can be up to the 50 million or 5% of annual income, which, depending on the size of the entity, could be an astronomical sum. Now, if an individual in the organization is held partially responsible or fully responsible for this organization's lapse, the fines on the individual start at 10,000 and can go as high as 100,000. Again, that's a pretty aggressive fine to levy on an individual person. So what do we do with all this? There are practical aspects for international data protection frameworks affecting you as in-house counsel and for international businesses. First of all, you do need to sort of get your arms around all of this if you're operating globally. It's a good idea to build data maps relevant to your business that help you track all of this. You want to prioritize your risk regions. Where are you most likely to get into trouble? Where are the most aggressive laws? Where are you doing the most business? Identify common baseline compliance elements across jurisdictions. So the goal here is to figure out, how do we comply with all of these laws, but don't treat them as separate obligations, separate laws. There are common threads, as we've seen, that weave through all of these and many other laws that we haven't looked at today. So if you design your compliance regime properly, it should be possible to comply with just about all of them. And it's important to stay up to date on the relevant global legal frameworks. And it's a lot of work to do this. And I frequently have companies say to me, the cost of compliance is just not worth it. And for a lot of small and medium-sized businesses, that's understandably the case. Unfortunately, there isn't any sort of proportional approach to how this is to weighing whether or not you're in breach. So it's just the unfortunate reality of doing business in 2021. You're going to spend a lot of money and a lot of time on compliance. Are there any questions?
Yeah. That's great. Back to Henry. We've received some questions, some really good ones, which I'm about to refer to and address, but we'd welcome anyone that has any questions to just put it into the Q&A section. I believe that they're all coming through as anonymous. So as they say, no such thing as a bad question, no worries about grammar or punctuation. But with that being said, thank you, Brent. And so you went through, certainly went through the jurisdictional regulatory web of data privacy standards. A question that is flowing from that is this, whether it's okay to just pick the strongest standard, for example, GDPR or California law to comply with, rather than trying to track and comply with all of the international laws that apply to a business.
It's a good start, but we shouldn't stop there, not least because the principles that underlie most of these statutes are the same or similar. The mechanisms can be very different. And ultimately, if a regulator takes you to task, they're going to be interested in knowing the extent to which you were actually mindful of their specific regime. But often compliance with one is going to allow you to comply with the others. So if you're going to do this, I don't recommend it, but if you're going to pick a regime, yes, pick the ones that are the most stringent and set that as your baseline, and you will avoid trouble in a lot of circumstances. But as we've seen in some of these, there are some basic differences still. There are some jurisdictions where you don't need to obtain further consent to transfer data outside as long as you've put contractual obligations in place that confer those requirements onto the processor. Other regimes still require a consent regardless. So that's obvious. Those are obviously, if you're going to comply with one that requires it regardless, that's a very different business model, and you're going to be having to figure out how to get that consent. It's going to hamper to some extent what people can do with the data once they have it, if they haven't already sort of anticipated all of the possible uses that they might want to put it to. So in a world of dreams, and as lawyers, we always say, no, comply with all of the laws, know all the laws, and you spend what it requires to do that. But as a practical matter, you're in better shape than not if you start with the most stringent laws.
Right. So it's the legal principle of aim high and hope for the best.
Yeah, like so many other things, many of things in the law. Yes.
Yeah. Okay. Here's another one, and I did take note. You mentioned in a couple instances the use of standard contract clauses as a means of compliance. I believe in the presentation it came up in the context of Schrems 2, and also when you were discussing Brexit and the trade and cooperation agreement standards. Sort of at a practical level, can you speak as to what typically would go into a standard contract clause?
Sure. So we see these typically spelled out as annexes to the laws. GDPR has them. And I should say the UK has come out with some guidance in light of Brexit to guide what's going to go into British-based contracts. But the principles are all very similar. And essentially, these are the kinds of provisions that under other regulatory regimes would simply be laid out in the statute and then deemed to be part of a contract. The difference here is that the way that it's done in privacy law is they require you to actually include it in the contract. So they deal with, they set out some standard definitions around controller, processor, the sort of the standard piece building blocks you need for the privacy statutes to make sense. And then they confer obligations on the processor, and they're fairly generically worded, but that's in keeping with the statutes to protect that data to a level that would essentially comply with the applicable laws. And the GDPR ones are as vague as that. They say it will apply with all applicable laws. And of course, if you're based in Europe, that means GDPR and potentially the laws where the jurisdiction that you're transferring into. And they set out those obligations. They set out a sort of a a tree of liability, let's say, where it's built into the contract that the controller is responsible for breaches of those applicable laws, regardless of whether they occur at the controller end or occur at the transferor end. The service provider end. But if for some reason it's not possible to pursue the controller, then that the remedy transfers to being as against the service provider. So if the company that collected your data goes out of business, you can still chase after the company that was processing it if there was a breach on their watch. So that's sort of the nub of it. It builds in those obligations and sort of guarantees some avenue of recourse and sets out an understanding as to who's first in that chain, because it wasn't always entirely clear to what extent the processor can be liable in these circumstances when it's a failure at the processor's end. But of course, your controller is the one that collected the data in the first place, typically.
Okay, no, that's great. Always good to know what goes into a quote standard clause on rather complex set of data points. Another question, and I had mentioned when I introduced you that part of your practice includes data breach class action defense work. So here's a bit of a softball question that came in that I'll lob to you. Should we expect all these new laws to result in more class actions?
The short answer is maybe, as with most lawyer answers, especially litigator answers. I think that we are going to see perhaps an emboldening of the plaintiff's bar. It's interesting because I'll use Canada as an example, but it's a typical example. We don't have, at the moment, we don't have that private right of action, and we don't have a nominate tort of statutory breach. So in Canada, you can't sue for breach of PIPEDA or one of the provincial laws. You can, however, sue in negligence, and the fact that the law wasn't complied with sort of sets the floor for a standard of care. And that hasn't really stopped plaintiffs' counsel from bringing data breach lawsuits, and goodness knows we have lots of them. And it's a wave that we're seeing, particularly now coming out of COVID as well, because there was so much hacking and malicious activity during COVID. I suspect we're going to see many more of those coming out. So in a way, it doesn't give you something that you didn't have before, really. But it potentially could. It depends on how that private right of action is phrased. If it's a right of action that doesn't require, and this would be a pretty wild example, but let's use it as a theoretical, a private right of action that doesn't require you to prove damages, that's enormously useful to the plaintiff's counsel because it's just a much, much easier case to make out. It removes a lot of the individual assessment of people's claims, and in many jurisdictions where class actions are available, what kills an action from going forward as a class action is the lack of commonality between the claims of individual persons in the class. So if the private right of action in any statute is set up so that it lessens a burden of proof, or makes it easier to bring a generic case where you don't have to deal with the individual circumstances of individual class members, it absolutely could result in certainly more claims and easier claims that are easier to sort of get over the threshold of what we call in Canada certification, but the process of the court approving an action to go ahead as a class action rather than as individual actions. So I think that the plaintiff's bar will certainly be happy to have it. But it hasn't stopped them from bringing those actions in the past.
Right. Okay, great. I'm going to take this opportunity to apologize to Tony, one of the people who asked the questions. I had said all of the questions come in anonymously, but maybe that's how you enter it. So I apologize for that data breach, so to speak. But Tony asks, could a U.S. federal law preempt the state laws that crop up ahead of any federal law? And I'll jump in. to your defense, Brent, by qualifying. Neither of us are U.S. qualified lawyers, but I don't know if with that proviso, if you have anything that you would want to address in that question or feel able to.
Sure. It depends, Tony. If the statute is set up in such a way that it's conceded that this is an area of joint jurisdiction and that you can either comply, you're either have to, it could base this on the Canadian federal model where the federal law applies in the absence of an equally strong and very similar state law. That's one model for doing it. But there are also many areas where you have concurrent federal and provincial law. So in this case, state laws, and they may simply overlap. I suspect, though, I mean, if the ultimate concern is compliance, I don't think that I would suspect that any federal law that's going to get passed is going to be as stringent as the California law and probably very similar. So I don't think you're going to see a scenario where there are wide swings in the requirements from state to state. This is a very, it's the fact that there's bipartisan support for a federal law on this. Even under the previous government, they just haven't been able to arrive at the exact law. But the fact that there's bipartisan agreement that this is a law that needs to exist makes me think that it's important enough, and that it's going to be the inclination is going to make the laws stringent, whatever it is. I don't think you're going to see it watered down in the legislative process. It's like passing a tough on crime bill, right? I mean, this is in a way, it's difficult to implement, but it's easy to write the law and it's easy to set very high standards. So I think what you may well see competing federal and state laws, but I think they're going to be very consonant.
Okay, that's great. And there are questions that are flowing in, so really appreciate the dialogue from everyone. That being said, I had asked Brent in sort of my capacity as moderator to do the presentation at 110%, and he complied. So we're doing reasonably well for time. So if you do have a question, by all means, feel free to throw it up on the board, and another one coming in anonymously. So I guess you have the option as to how the question pops in. Here's one of interest, and you were talking, Brent, throughout the presentation about sort of keeping an eye on regulatory matters across global markets. You know, how do you do that? You know, and what specific sources might you recommend for in-house counsel or counsel generally in trying to stay abreast and keep a track on the changes that are happening on, you know, in the global market, global regulations, or regulations globally, I guess I would say.
Yeah, I would love to have a piece of software in my computer that gives me a dashboard into all the countries in the world that have these regimes. I haven't seen that yet, but it will make lives a lot simpler and possibly result in fewer privacy lawyers, and certainly on the defense side, if we had something that keeps us all that organized. There are a lot of private publishers that are putting out really good resources on this. One of them is the Chambers Global Guides. They have a substantive law one devoted to cybersecurity. I think that they last year, I guess, to be on their 4th edition. Actually, I had the pleasure of being one of the co-authors for the Canadian edition of the Canadian chapter of the 2nd edition in 2019. And that it's a book about that thick, comes out every year, and it gives you a good overview of what's happening in most of the key jurisdictions in the world. And they are structured so that you can jump to the same topic for each country and find the answer quickly. I'd still like to see something like a massive chart that sort of maps all this out in a searchable way, but I haven't seen that yet. I'm just frankly following a lot of law firm newsletters, and you know, in Canada, the US, I'm following what the regulators themselves are saying. But it really is something that you have to sort of do a lot of reading on and check more or less constantly. So there's an invitation to commercial publishers and software publishers. That's the tool I would like to see next in terms of legal tech.
Yeah, sounds like there's a business idea there. Maybe we should consult with our UK colleagues on the AI and see if there is something to be done in that regard.
Absolutely.
Uh, yeah,
And any of the global firms you'll find have fairly good coverage of all of the places that they're doing business and keeping an eye on, and ours is certainly one of them. So sign up for the newsletters and just keep an eye on things.
yeah, that's a great point. Um, I'm just going to canvass our board to see some of these questions kind of come in through alternate channels. So just taking a look to see if there's anything else that's currently outstanding. I'm just looking at through my email as well. While I do that, I don't know if there's anything else that you wanted to add or go back to or emphasize, Brent.
Hmm. No, I think I've probably said more than I know.
Yeah, yeah. Okay, and I've just yeah, that's great. I've just done my look through. So if there is nothing further, no doubt we have not answered all the questions in the global universe of data privacy issues. So please do feel free to reach out to us, to Brent or myself, and both jurisdictionally and expertise wise, we would be more than pleased to answer your question or put you in touch with one of our colleagues in the appropriate jurisdiction within our global platform. And
absolutely. And we don't compete with your regular lawyers. We don't have offices in Canada for business reasons. But we work very closely with a lot of favored nation firms in the US and probably ones that you're already using. So always happy to help.
Yeah. And if anyone joined us midway through and were so inclined to listen to this entire presentation or part thereof, this will ultimately be, it's being recorded and will be posted online. So if your preference is to listen at 80%, 90%, or 110% speed, that will be available. As mentioned, we have our final session on Thursday on artificial intelligence for European perspective. I will be tapped into that with interest. One of our presenters has actually written a book in that area, so sure to be a good session. And other than that, I wanted to once again thank everyone on behalf of my partner Brent, Henry Harris, and we are delighted that you could take some time out of your early or mid afternoon today to join us. Thank you for some very good questions and dialogue, and we do hope that you found it helpful. Wish everyone to be safe, to be well, and to be productive. And all the best. Thank you for attending.